Hello again, my name is Yvette Gasic and welcome to our webinar, Sponsoring Skilled Migrants, All You Need to Know, presented by Citation Migration and Citation Legal. Before we dive into the presentation, I'd just like to cover off some general housekeeping rules. If you have a question during the webinar, please use the Q&A feature at the bottom of your screen and we'll try and answer them at the end of the presentation. You do not need to wait until the end. You can type your questions in at any time during the session. And yes, this webinar is recorded and you will be sent a link to the recording after this session. It's great to see so many of you here today joining our webinar. Given the strong attendance, I'm guessing you're here to learn more about the latest changes in Australia's migration space and how also that applies in the employment law context. This is particularly focused around employer-sponsored visas and what they mean for your business. We'll also touch base on best practice approaches, compliance obligations, and also provide some real case examples that highlight lessons for employers. Next slide, please. So today, our webinar will be presented by myself and Lisa Qiu. As mentioned, my name is Yvette. I'm the head of migration at Citation Migration. I have over 20 years of experience and I've worked on all sides of immigration, assisting organisations across several different industries, including health, engineering, hospitality and logistics, to name a few. Lisa Qiu is a partner and a solicitor at Citation Legal. She specialises in employment law and business migration, advising employers on compliance, workplace disputes and legal risks when engaging skilled migrants. Next slide, please. Many of you here today have partnered with us on HR or safety, but Citation Group is more than that. For over 30 years, we've provided end-to-end workplace compliance support to Australian and New Zealand businesses, from HR and safety to ISO certification, workplace law, and of course, immigration. Next slide. The arm of Citation Group I work in is known as Citation Migration, and Lisa works in the Citation Legal arm of Citation Group. So for over 10 years, Citation Migration has been providing Australian businesses and individuals with advice, strategic assistance, and practical solutions for all migration and citizenship issues. If you're seeking immigration services, we're here to help you and support you on that journey. Citation Legal, formerly known as FCB Workplace Law, has been providing legal advice to employers for over 30 years. If you have a legal issue, including the need to be represented in court after receiving a claim from an employee, or if you need assistance with handling a particularly complex or high-risk employee issue, please reach out to Citation Legal. Okay, moving on. So the agenda for today, we're going to start with an overview of recent updates to the migration strategy, specifically employer-sponsored subclass 482 visas. We'll then move into some sponsorship obligations and recent case studies, give you some best practice as employers to be aware of, then navigating the employment relationship, the hiring, the firing, and the in-between, and what to do when the Fair Work Ombudsman or the Department of Home Affairs comes knocking. So let's make a start. Next slide. That's me. Moving on. So overview of the migration strategy, we're going to provide you with an update on that. So for those of you who may not be familiar, moving on to the next slide. The migration strategy was introduced or finalised in December of 2023. The government took a view that our immigration system, in their mind and view, was broken and needed fixing, and as a result, undertook a review. Coming out of that review were a number of recommendations, and those recommendations were essentially put down and summarised into 8 key action items. I'm not going to go into all of those today, but the focus of the ones I'll talk about are those actions that related to targeting the temporary skilled migration visa programs and the skills needed to promote worker mobility in Australia. So as a result, the government decided to partner with Jobs and Skills Australia And Jobs and Skills Australia's role is essentially to provide the government with independent advice in relation to where the shortages are essentially across Australia. They have their finger on their pulse and are able then to very quickly and easily update what now is called the Consolidated Skills Occupation List, formerly the CSOL. It's now called the CSOL, but it was called other things previously. We had other lists. So it's now all consolidated into one list. Whilst it's all the one list, 3 streams were introduced. So the Skills in Demand visa, as it's now known, formerly the TSS, Temporary Skills Shortage visa, has now been replaced by the SID, and it has 3 targeted pathways. So the first is the Specialist Skills Pathway, and that is to make it easier for Australians to attract highly skilled workers, for example, technology or in the green energy industries. Then we have what we call the Core Skills Pathway, and that's there to meet targeted workforce needs, providing a simpler and a more regularly updated occupation list for the skills Australia needs. The first pathway I mentioned doesn't rely on the CSOL list. It's really that second stream of core skills. And then the third setting relates to the labour agreement stream. And for those of you that might be familiar, they're independent agreements that either companies or industries can directly negotiate with the Department of Home Affairs to obtain tailored occupations and needs, concessions provided under the 482 visa program to meet your business's needs to be able to utilise the program. And then we can talk about, in particular, the Core Skills Income Threshold, which was previously known as a TSMIT. And as you know, there's a number of acronyms there that immigration likes to use, but it's now called the CSIT. And what that is, we might move to the next slide. From the 1st of July, those thresholds, the CSIT thresholds, which only apply to that second stream I mentioned, the Core Skills Pathway, and also the Specialist Skills Pathway, it's increased from that 73,150 under the Core Skills to 76,515. That's excluding superannuation, and that's the base salary. And then the Specialist Skills Income Threshold for the Specialist Skills stream, that first stream, it's increased from 135,000 to now being 141,210, excluding super. So this affects all nominations that are lodged under that Specialist Skills stream. And similarly, the previous one of 76,515 only applies to that middle threshold of the core skills threshold for the core skills pathway. Can move on to the next slide. And so what does that mean for you as employers? So for new nominations that you've lodged post 1 July, you'll need to meet that new updated income threshold or the annual market salary rate, whichever is the higher. Those of you that are familiar with the program will know that you need to be able to show that what you're paying the sponsored worker that you're considering for the 482 visa is at the same level or higher of what an Australian in an equivalent role would be paid. So as part of the application process, you do need to provide market salary survey data to show and support that you are actually paying your foreign employee the equivalent of what the Australian market rates are for a similar role. You can also demonstrate that by providing evidence of an existing Australian you have in your employment that is being paid the same salary. So existing visa holders, those who already hold a 482 visa are not affected by these income threshold changes. Except if you decide that now you are going to responsor or they need to extend their 482 visa, the new thresholds would apply. From the 1st of July, we're all aware that the superannuation guarantee levy also went up, and that's increased now to 12% from the 1st of July. So you need to make sure that when you are talking about guaranteed annual earnings for your employees, you're not inadvertently reducing their guaranteed earnings as a result of the superannuation rate change. Next slide, please. Another visa which was introduced as part of this migration strategy, which is not the 482, but is another visa class. It did exist. It was previously called the Global Talent Visa. It's now just been rebranded. The subclass is still the same. It's an 858, but it's now called a National Innovation Visa. And the aim of this visa is to attract diverse, high-caliber talent from various backgrounds and offers a unique pathway to PR for those who can significantly and contribute to the Australian economy. For New South Wales, the nomination program for the National Innovation Visa has now opened, and you actually have to lodge what we call an expression of interest to be invited to apply. New South Wales has identified key priority sectors for the next 4 years, and each state has actually done that, but I've just focused here on New South Wales, but certainly happy to provide others with that information if interested. And New South Wales will prioritise candidates who align with these 6 critical skills areas. So the industries include construction, so infrastructure and housing, obviously energy, so net zero and energy transition type occupations, or professions, the care and support economy, so of course healthcare, digital and cyber, agriculture and agri-food, and advanced manufacturing. So what are some of the common visa conditions that for you as an employer hiring an employee that holds a visa, not necessarily just a 482, but other types of visas, what do you need to be mindful of? Next slide. So common ones are, some of you may use students and employ students, and that's certainly allowable, but you need to be mindful that student visas do carry certain conditions, and often they're considered, the common ones are the work limitation conditions. So for a primary student visa holder, the work limitation condition 8105 is a very common one. And this condition means that the individual can't work in Australia before their course starts, unless at the time of applying for this visa, they held another visa that permitted them to work. The other thing it says is that you can't work for more than 48 hours a fortnight when your course of study or training is in session. That means when your course is, you're currently attending classes. You can only work over 48 hours a fortnight, and there are some exceptions, and these are the exceptions. If your course is in session, you can work full-time if you are holding a master's or studying for a master's degree by research or a doctorate degree, so a PhD. The other is that if you are a registered part of a course that's mandatory, and it's specified as a requirement of the course that you entered through the Commonwealth Register of Institutions and courses for overseas students. Course of study is in session, so just so you know, for the duration of the school semesters, including when exams are being held, or you take another course that will count towards your main course during a term break. So it's important to be aware of that, perhaps as an employer, if you're aware that that's happening. The other condition is 8516, is that you continue, and a student must continue to satisfy the criteria for grant for the visa. So non-compliance may be due to a significant change in circumstance, which may or may not be outside the control of the student, and may include a relationship breakdown, inability to access funds, changes in enrolment shortly after arrival to avoid the requirement to provide English language requirements. So that's quite a lot of detail. I guess the key one for you to be aware of is how many hours they can work with you. So anyone who is studying anything other than a master's by research or a PhD can only work 48 hours a fortnight whilst they're in your employment. Next slide. So family members of student visa holders, and we might actually skip to the next slide. It summarises it nicely, is that if you are employing someone who is the secondary visa holder of a student visa, that is, they're a family member of someone who's studying, if their partner is studying a bachelor degree or lower, they're limited to 48 hours per fortnight while the student is studying. So while their course is in session, they can only work 48 hours with you. If their partner is studying a master's degree or a PhD, they have unlimited work rights. And so they can work for you full time, which is unlike the main student visa holder for those that are just studying a master's degree. So be mindful of that and important to check. Next slide. Working holiday makers. So obviously this is another one that causes some concern, and we often get a lot of questions from employers about this. All working holiday visas, whether it's a subclass 417 or a subclass 462, carry two mandatory conditions. One is the 8547, and that basically says it's a work limitation. They can only work for the one employer for 6 months at a time. And there are exceptions, of course. But we could go through some of those exceptions around critical skills. So if your industry is in what we call a critical sector, and so that includes healthcare, that includes hospitality and tourism, to name a few, agriculture is another, they can work for more than 6 months with you. The condition 8548 is a study limitation, so they can't study for more than 4 months if they hold a working holiday visa. Moving on. I wanted to mention this about existing 482 visa holders. It's not so much a condition, but rather a change that's occurred that is very relevant for those of you that may be looking to hire someone who might already hold a 482 visa with another employer. So you can currently hire someone who holds a 482 visa without actually having a nomination approved straight away. So if someone came across your desk and they had met all the requisite requirements and you wanted to hire them, you can. What essentially is required is that you do ultimately apply and lodge a new nomination application under your sponsorship. But the individual who holds the 482 visa gets 180 days from their last date of termination with their former employer to obtain a new sponsorship. So you get 180 days to finalise that, provided the validity on their 482 visa also has 180 days on it. So as long as the ANSCO is not going to change, that is, the occupation that you're going to hire them for does not change, and they remain in the same occupation, then you can simply just do what we call a nomination transfer, and you have 180 days to do that from the date they start with you, or from the date they're, more importantly, from their date of termination with their prior employer. So it's important to diarise that date so you know how much time you have. And this also applies to 494 visa holders for those of you in the regions. It can also apply to a 494 visa holder. And next slide, please. I wanted to mention here compliance, and in particular a piece of legislation that is often overlooked called the Employer Sanctions Act. Essentially what that means is employers must verify that their employees have the right to work. Each of you may have your own way of doing that. More often than not, the common way is through a Vivo check, or sometimes employers will reach out to us to do that for them. Others may have a system or a software whereby you can actually run those checks. We do also offer that software as well for anyone who might be interested. But an employer is liable, that is, you as an employer are liable if you're found to have allowed a person to work in breach of their work rights. This applies not only to your employer-sponsored work visa holders, but it also applies to any employee or contractor working at your place of business on a visa. So, for example, international students, working holiday makers, and partners of visa holders would be captured by the Act. And the penalties are actually quite significant. There are civil penalties that can be imposed on a business. So it could be up to $81,000 per worker in breach of their work rights. So that's for the employer, and $16,200 per worker for a director or officer of the company. Sorry, it's the other way around. It's actually the individual would pay the $81,000 and the director or the officer of a company would be paying the $16,200. Where the breach was known to the employer, or they're found to have acted recklessly, then there's a criminal liability applied, and it can arise for up to a penalty of $270,000 imposed on the business, and end up to potentially $54,000 in fines, and or potentially 5 years in jail for directors or officers. So they can be personally liable. So it's quite important. A liability can apply regardless of whether the business realised or not that the worker was in breach of their visa. You can rely on a statutory defence and avoid these penalties by taking reasonable steps and at reasonable times to check visas. So you could potentially use that as a defence, but it's not necessarily going to be the silver bullet to being potentially found in breach is going to be quite discretionary. Moving on. So what are some best practices that you should follow as an employer? So we talked about VIVO. So seek consent from your visa holders to perform a VIVO check to confirm their work right status. Ensure your employment contracts, particularly of foreign workers, include a clause that require them to maintain a valid work visa and obtain consent for you as their employer to perform VIVO checks throughout the term of their employment. Periodically check their work rights by performing a reasonable check to meet that requirement under the Act and do it at reasonable times. So generally, most of our clients will diarise to perform a three-month check every quarter to check the visa status of their employees. However, where a visa is subject to change, that is, you have an obligation to notify in 28 days of any changes. Make sure you're monitoring that, and perhaps more frequent checks might be required. You'll need to maintain records to show a clear audit trail and provide evidence of compliance in case you're audited by immigration. So you might want to consider outsourcing your VIVO checking obligations to an external provider who can notify you of any changes to visa status of your employees and ensure that you remain compliant and that you're undertaking those activities as required by law in terms of the checking. So that is something we do for a number of clients. Have clear recruitment processes that ensure that the work rights of all your workers are checked at the time of onboarding. At a minimum, you should collect a copy of an Australian passport or a birth certificate or a New Zealand passport for New Zealanders. So obviously, best practice is to have a copy of a foreign passport and a VIVO check at a minimum on the records of each of your employees. Next slide. So what are some of these obligations I was talking about? So sponsorship obligations apply to all sponsors under the 482 visa program. And when you sign the forms or you confirm and lodge an application and have a sponsorship approved, there are a number of obligations that you are taken to have agreed and consented to. So let's go through some of those. I won't go through all of them, but here are the important, I'll reference the important ones. So a very important one, of course, is to cooperate with Home Affairs inspectors in case they request things or attend your premises. Ensure that the person that works with you and is sponsored works in the nominated occupation they were approved for. Ensure that the sponsored person has the equivalent terms and conditions of employment as an Australian citizen or permanent resident performing the same work in the same location. And notify Home Affairs within 28 days when certain events occur. So these are some of the things that you should definitely take a note of. And that is, if a sponsored person ceases working with you, even if they're going to leave and go to another employer on a 482, you must notify within 28 days of their last day with you. If there's a change to their work duties, immigration must be notified. If a sponsored person fails to commence employment with you, we need to notify immigration within 28 days. If the company has paid return travel costs of sponsored persons or their family members, we'll talk more about that in a moment. If there's a new director appointed to the company, we need to notify within 28 days. So often an extract of ASIC will be valid and evidence of that change. If there's a change to the company's business address and or contact details, if the company enters into insolvency or becomes and goes under voluntary administration, we need to notify immigration. Next slide, please. We spoke about paying travel costs. So this is something that over the years and pre-2018 was a compulsory requirement that employers did that and paid for return travel costs. That's no longer compulsory unless the individual requests it in writing. So they must request that in writing, and you're required then within 28 days of the request to pay all reasonable and necessary costs for them to leave and return to their country of origin. So there's certain prescriptive criteria around what they need to request in writing. So what are reasonable and necessary costs? It's basically an economy class airfare for them and their family to return back to their country of passport. If, for example, the person disappeared and immigration did locate them, and this is separate to them requesting in writing for you to pay their travel costs, the Australian government may require you to reimburse the Commonwealth if that individual has to be deported and they can't be found. And that individual often is going to become unlawful unless they are removed. It could be that it does come back and that you are requested to pay those removal costs if they can't recover it from the individual. And there are a few other things there that you'll need to take into account around reasonable and necessary costs. The other very important sponsorship obligation is to note that you're not to engage in any discriminatory recruitment practices. So you're advertising your roles, be very careful. And of course, I imagine most of you are across that anyway, that you can't, obviously advertise and say we only want a female, or, we only want a certain gender, or, as I said, or race, or whatever it might be. Yes, you've got to be very careful about your advertising. So if you're found to be in breach of that, that can adversely affect your sponsorship obligations because it's considered under the Act as adverse information. Moving on, because I'm mindful of time, obviously Lisa has quite a bit to cover as well. There are some case studies here that I've extracted. I might leave you to read those, but essentially what they're highlighting is an example of a client we assisted where they received an audit, what we call a notice of intention to take action, which was an audit of a logistics company where they were concerned about the equivalent sort of salaries they were paying their foreign workers as opposed to Australians in an equivalent role, and then also the advertised position that was offered and why they didn't offer the role to other candidates who were, well, perhaps not exactly qualified as the candidate, but there were some discrepancies in the evidence that was provided to the department. So I'll let you read that, but you'll see those obligations that I mentioned earlier around your sponsorship obligations. This is where it comes up, is when an audit is undertaken. You need to be able to have good records to be able to show and produce to immigration at fairly short notice around your foreign workforce. We might move on to the next slide. And so this was a success story of that logistics company where ultimately they weren't found or barred in terms of the outcomes that could occur, but they were given a warning. So if they're found to be in breach again, then they're potentially risking their sponsorship, and not only for the 482 program, but for the permanent residence or any other type of visa they might want to sponsor individuals for. It would affect any type of visa if they're found to be in breach. Moving on then, this is the last slide from me. It's just, if we could move on to the slide, it's essentially just setting out what sort of costs you as an employer can recover from an individual that you sponsor. So essentially for a 482 visa, you can recover anything related to the visa. So that is the visa application or professional fees relating to applying for the visa, but anything related to sponsorship, that is the sponsorship application itself or nomination, you cannot. You can't recover that from the individual. You can include what we call a clawback clause as part of an employment contract, either as an addendum or in the body of a contract. And essentially it just set out how you would recover those costs back after a period of time. For example, if they left within 24 months, for example, that's often what most of our clients put in. But I might let perhaps Lisa talk a little bit more about those sorts of things. And I might now hand it over to Lisa.
Thank you so much, Yvette. So thanks everyone for joining. As Yvette said, I'm a partner based in Citation Legal. So let's get into the employment law considerations when it comes to hiring, firing, and the in-between for managing the employment relationship of visa holders. So next slide, please. So if you've ever been involved in sponsoring a skilled worker before, you'll know, having done work with migration agents and lawyers, that it's quite often necessary to provide the Department of Home Affairs a copy of the employment contract that's going to be offered to the visa holder so that the department can be confident the visa holder is going to be employed on at least the same terms and conditions as an Australian employee. And you'll also often need to provide an example of the employment contract for an Australian employee so that the Department of Home Affairs can be assured that those terms and conditions are going to be the same. So setting up the employment contract and turning your mind to what the terms and conditions should include is often one of the very first things that you need to consider as part of the visa application process. And you're often having to think about the terms of an employment contract much more in advance than you would if you were offering employment to someone who didn't need a visa and was going to start work shortly. So it's really important that you make sure that you consider all the different terms and conditions within that employment contract that you need to have in there from a visa perspective, but also that adequately address any employment law considerations that might come up. So if you don't get it right, what I often see in my practice is that there are issues that can arise years down the track even, when the parties have to look at the terms and conditions of the employment contract and go, oh, we forgot to put this on, we forgot to put this in the employment contract, or this aspect of the contract wasn't clear, and there becomes quite a long dispute that needs to then be dealt with at that later stage. So some of the things that you should be thinking of in the employment contract is to consider when the employment actually commences. So as soon as an employee actually signs an employment contract, you've offered it, they've accepted it, their employment can actually commence from the date that they actually return that employment contract. Even if they haven't actually started in the role yet, the employment contract is the employment relationship arguably is on foot from the date that they sign and return and accept the terms and conditions of employment. What I often see in employment contracts that have been drafted for the purpose of supporting a visa application is that the contract is silent as to when the employment commences, and that can be problematic if, for example, you say that the employment commences, say, on the 20th of August 2025, and the visa is not granted by the 20th of August 2025, and let's say the employee is overseas. Then if they're not actually able to get in Australia to perform the role from the 20th of August 2025, they could potentially claim for wages from that date, even though they can't actually start performing the role in Australia. So when I'm looking at reviewing employment contracts that I know are going to be provided to the Department of Home Affairs, I like to make sure that there is provision in the employment contract with respect to the commencement of employment. So you either say that it will commence from the 20th of August or from, 5 business days from when the visa is granted, whichever is later. So sorry, there's a mistake on that slide. It's not whichever is earlier, it's whichever is the later. So whichever, the start date essentially needs to be after they get their visa approved, unless there is some option for them to commence work overseas and remotely without them having to get their actual visa granted in order for them to do that. And if that's the case, then that understanding should be built into the employment contract as well. Another consideration is whether or not a modern award is going to apply to the role. So people often think, or employers often think that, oh, I pay above minimum wages or I pay above minimum award rates, so therefore the award doesn't apply and it's only the employment contract that applies. That's not quite correct. The employment contract sits on top of any modern award that applies. So you can't contract out of a modern award. And even if you're paying someone above the modern award minimum rates, all that means is you're complying with the minimum rates under the award, but there are all different types of provisions in relation to breaks and allowances, when employees can work, when they get, when they're entitled to overtime or penalty rates, etc., that you should still be mindful of. There's also a requirement under modern awards that if someone is covered by a modern award, that they're actually notified of that in writing at the commencement of their employment. So if you haven't turned your mind to that and you haven't put anything in the employment contract that talks about whether the role is covered by an award or whether it's award free, you can have a situation, and we see this often, where 5 years down the track, the employee says, actually, I think I was classified as a level 5 under the retail award, for example, and I don't think I've been paid at that correct rate for the past 5 years, and all of a sudden you have a big underpayment dispute. So it's good to turn your mind to that early on and to set out that expectation in the contract so that the terms and conditions of the employment are clear for both parties. If you're going to be paying above the award and you're offering a salary, which is often what you will offer to the visa holders, because the Department of Home Affairs wants to be assured that it's above those minimum rates, the minimum salary requirements, so the previously called the TSMIT, as Yvette was saying. If you're going to pay above the award, just make sure that your employment contract as well includes a clause that says that the salary that's being offered is inclusive of all entitlements under the award. And that there's also a further provision which is called a set-off clause, which says that if you're going to allege that you're entitled to penalty rates under the award, that we can set off your claim against the amount we pay above the award. So next slide, please. So I'm just going to... So there's just some background noise, I think, in my house. Apologies for that. So another consideration is, and we saw this a lot before, not so much now, but often a visa requirement, especially for the previous 482 visas, was that the visa needed to be valid for at least 4 years. And what we were seeing from employers is that they were changing a template employment contract to say this contract is valid for 4 years. And then sometimes they inadvertently amended that contract so that it became what's called a true fixed term contract. True fixed term contracts are those that don't actually provide for notice of termination within the term of the contract. So if you set up a contract that says it's for 4 years and you take out the provision in the contract that says you can terminate within the 4 years by providing, say, 4 weeks notice. If you take that additional notice provision out, if you wanted to terminate the employment for whatever reason, for example, let's say underperformance or serious misconduct, you could potentially have an employee turn around and say, well, hold on, you promised me that this contract was going to be for the entire 4-year period, so you need to pay out the rest of the 4-year contract. So just make sure that if you are changing your employment contract templates for the purposes of a visa, that you're not inadvertently turning it into a true fixed term contract. There are also prohibitions on fixed-term contracts that were introduced under the Fair Work Act on the 6th of December. And those prohibitions meant that if you're going to offer a fixed-term contract, you can't actually offer a fixed-term contract that is for 2 years or more. If you're going to offer a fixed-term contract for 2 years or more, there needs to be an exemption which applies in relation to the fixed-term contract prohibitions. Otherwise, you should be looking at offering a permanent employment contract. Yvette also briefly mentioned the clawback provision. So, for example, if you're going to offer to pay the visa costs associated with a visa application, so not the nomination or the sponsorship costs, because those need to be paid by the company, but if you're going to offer to pay the visa costs, which you can actually ask the employee to pay, and you want to make sure that the employee is going to repay some of those visa costs, especially if the visa costs include secondary applicants or members of their family. When you're issuing that employment contract, consider adding in a clawback provision, which essentially sets out that the employer can claw back some of those recoverable visa costs if the employee decides to resign from their employment for whatever reason within a certain time period. So just an example that I had back in the day when I was much more on the tools from a migration perspective, I had a client who had lodged a global talent visa, so they were a company, and the employee was migrating from the US with her daughter, and the company agreed to pay all of her relocation fees and all her visa fees associated with her global talent visa and the secondary visa for her daughter. And the employee decided just not to turn up for work. So she came to Australia, she got her permanent residency. The permanent residency that was granted as part of the global talent visa didn't require this employee to only work for my client. They could do any type of work in Australia, but there was that acknowledgement as part of the global talent visa that, or that was that the expectation that she would actually start work for my client when she came to Australia. So the client contacted me and said, look, she hasn't turned up for work. We can't contact her. We've spent thousands and thousands of dollars getting her and her daughter this visa. Can we recover any of those costs? And I said, well, did you have anything in the employment contract that set out that was essentially a clawback of those costs? They didn't have that. I said, is there anything outside of the employment contract, such as a separate standalone document that talked about recovery of visa costs? And they didn't have that either. So that left them in quite a difficult spot. So lesson to be learnt from that. Again, if you're going to be spending quite a bit on the visa process, just turn your mind to those potential worst case scenarios where the employee decides that they don't want to follow through on their end of the bargain, and what is the company going to do to recover their costs, and what do you actually need in your contracts right from the beginning to enable you to do that. Another consideration is for employment contracts is a restraint of trade. So a lot of employment contracts will say after you cease your employment with the company for whatever reason, you can't work in competition with the company in a certain area for a certain amount of time, and you can't solicit or try to take away business from our clients and contacts, etc., for a certain amount of time after the end of your employment. When it comes to visa holders, one thing to be mindful of, especially visa holders who can only work for certain companies or for a certain employer, is that when a court considers whether that restraint is actually enforceable, so we're talking about at the end of the employment relationship, one of the things that a court will consider is, well, is this restraint reasonable in circumstances where this employee can only work for certain companies in Australia and they have to go through that visa process in order to be able to work for a company? So in other words, the reasonableness of a restraint is going to be watered down in situations where you have a visa holder. So that's something to be mindful of if you are in a business where restraints are really, really important and you do rely on them often. Next slide, please. So we've covered just that third bullet point at the bottom. So the employment contract, we've sort of covered most of those. The first couple of points are in relation to forward thinking at the beginning of that engagement or those discussions with a potential employee, or perhaps an existing employee who wants the company to sponsor them. They might be on a student visa or a working holiday visa, and they're asking the company to sponsor them for, say, some sort of working visa. Speak to, Citation Migration about the potential pathways for that employee, because if you want to invest in that employee only if you have some surety that they're actually going to be able to stay in Australia working for the company for a few years, so not just on a temporary basis, and the ultimate goal is to get them permanent residency, then that can inform the type of visa that you apply for or support them in applying for in the first place. There are some roles and occupations which are on where converting to permanent residency is going to be a little bit more difficult, and it may require them to be on a few different visas before they can get to that pathway. But they're all considerations to think of at the beginning of that employment relationship, perhaps even before you even offer the employment contract, because there's going to be considerations in relation to costs as well for actually helping them to get permanent residency. If it is that after you speak to the migration lawyers, they say, well, look, we don't actually think that this person's going to be able to get permanent residency, or it's going to cost this amount of money to get them that, then that's something that you might need to consider internally in terms of which candidate are you going to offer the role to. Just in the last arrow on that slide. So one of the other considerations in the employment contract that I haven't touched on is notice. So in the employment contract, it will say that if either party wants to terminate the employment relationship, this is how much notice is to be provided. And quite often the employment contracts will say that notice is in accordance with the national employment standards, which ranges from 1 week to 5 weeks, depending on their age and their length of service at the time of termination. With visa holders, I always recommend considering whether you want to provide slightly more notice than what's set out in the NES, and I'll talk about those reasons later when we get to some case studies. Next slide, please. So, so we've talked about considerations at the beginning of the employment relationship and what you should be turning your mind to when you're offering the employment contract. I just wanted to touch now on some considerations during the employment relationship. So of course it all depends on the type of visa that the employee holds, but if they're on the TSS visa, then they can only work for the role which they were nominated and for the company that was approved to sponsor them, and on the terms that they were approved for. So generally under that visa, they'll have to work. It's generally full-time employment, I believe, and at a certain level of remuneration which has been approved as part of their nomination. I've come across circumstances where a company is looking to make various roles redundant, and as part of the redundancy consultation process, they want to explore, or they must explore in certain circumstances, depending on whether the role is covered by an award, they must explore whether there are any other suitable redeployment opportunities for the affected individuals. If you have an employee who is on a visa that only allows them to work in a certain role because that's what their skills are based on and that's what the department has vetted them to work in, you can't simply redeploy them into a different role that might be in breach of your obligations as a standard business sponsor. Likewise, as part of the consultation process, employers often consider whether they can reduce the salary of an employee as a short-term means to avoid redundancy, or sometimes they think about reducing that role from full-time to part-time, again, as a way to avoid redundancy. Just be mindful and get some migration advice before you do that, because while that can be done from an employment law perspective, again, you might be running into issues from a migration perspective. Yvette's already spoken about certain visa conditions, so I think we can go on to the next slide. Another thing to consider is, even if you're going to offer an employment contract, and even if the employment contract sits on top of an award, there might be other instruments, employment law instruments that apply to the employee's role that govern the terms and conditions of their employment. So I'm not sure if any of you on this session today have enterprise agreements, but if you have an enterprise agreement, that might also cover this particular employee who's on a visa, and if the enterprise agreement does cover their employment, despite the fact that they didn't vote for the enterprise agreement, you need to be mindful that you ensure compliance with the terms and conditions of that enterprise agreement. I had a client who had a particular group of employees who were on visas and who were offered relocation allowances as part of their package to come to Australia, in addition to the employer agreeing to pay their visa costs. Those group of employees were also covered by the terms of an enterprise agreement, which provided for certain incremental increases over time. One of the employees within that cohort raised an issue with my employer, in that they were of the view that they were covered by the enterprise agreement and should have received those incremental increases. And my client initially was of the view that because they had paid this cohort of employees a relocation allowance and their visa costs, that meant they weren't covered by the enterprise agreement, which wasn't correct, unfortunately. So we assisted in our client in dealing with that issue with a cohort of visa holders. But the lesson to be learnt there is just be mindful that you know exactly what terms and conditions outside the employment contract might still apply to them. If you do breach the terms of an award or an enterprise agreement, or an NES term in the Fair Work Act, it's a contravention of the Fair Work Act, so there are penalties that can apply. And Yvette's also talked about some obligations of employers under the Migration Act. For example, making sure that employers should make sure that they take reasonable steps at reasonable times to satisfy themselves that they are not allowing an unlawful non-citizen to work. So that is someone who doesn't have a visa, or a lawful non-citizen, so someone who has a visa, to work in contravention of their visa conditions. It's important to not only ensure that you know who is on a visa and what the terms and conditions of their visa are, but that you also have evidence to satisfy yourself of the status of your Australian citizens and permanent residents as well. So a lot of what we do in Citation Legal for our clients is to undertake compliance review checks for their business and for those within their supply chain. So a compliance review check is to essentially do a spot check of a cohort of employees, either directly in their workforce or within the workforce of a company within their supply chain, and to make sure that we're comfortable that the employees are receiving their minimum wages and terms and conditions of employment under whatever relevant instrument applies to them. And we often will ask employers to show us the right to work documentation, which for an Australian citizen is essentially their passport or birth certificate, etc. And I've had circumstances where employers say, well, if someone says in our induction process that they're an Australian citizen or a permanent resident, we don't ask for proof of that. It's only when they say they're not an Australian citizen or permanent resident and they have a visa that we ask for evidence of the visa. So that can just make sure that it's, yes, it's not just your visa holders, but your Australian citizens and permanent residents where you've got those records as well. So I'm just mindful of time, so we'll move on to the next slide. So considerations at the end of the employment relationship. So obviously everything works well until it doesn't. When it comes to terminating the employment relationship, just be mindful that for employer-sponsored visas, the employees have, it's 180 days now to find a new employer to sponsor them. So it means that if they can't get things sorted within the period of time, then they could often face having to leave Australia. And if they've got family members with them, so a partner who's working or kids that set up in school here, that's not actually a lot of time for them to sort out their affairs. And the fact that a visa holder may only have a short period of time in which to find alternative employment or otherwise risk having to go back to their home country can have an impact on unfair dismissal claims. So next slide, please. So I'll just go through one example. So in this case, Mr. Richard Patinella was from the US. He held an Australian visa. He was terminated for essentially misconduct. So on the right-hand side, I've set out one of the emails that he sent to his employee, some really colourful language in there. He was terminated for serious misconduct, and he was on what was a 457 at the time. Next slide, please. He lodged an unfair dismissal claim, and despite the Fair Work Commission finding that, yes, there was a valid reason for the termination, that is, they found that, yes, he had engaged in misconduct, they nonetheless found that the termination was harsh because of the impact that it would have on him as a visa holder. And in the extract there, Commissioner Asprey said it was, in my view, it's relevant that Mr. Patinella travelled to Australia from the US. Mr. Patinella was in an extremely vulnerable position in that if he did not secure alternative employment within 28 days of his dismissal, as it was then, he could not remain in Australia. So I've set out the lengthier quote in there for you to read, but that is why I suggested earlier on that when you were looking at the employment contracts for an employee on a visa, that you consider building in a little bit more notice than the minimum requirements, or that at the time of termination you consider providing them with some additional notice than what they're contractually entitled to, or you explore other alternatives such as allowing them to utilise their accrued leave, for example. So actually, I think I might have these on the next slide, or we might have to flick through the next few slides. That's another example. I'll leave that for you to read. Again, the Fair Work Commission found the termination was harsh because of the visa status. Next slide, please. This slide was a more recent one that essentially went through the same thing. Next slide, please. And next slide. Yeah, so the lessons from those unfair dismissal cases is to consider providing more notice. You're absolutely at your discretion to be able to give them more notice if you're terminating the employment relationship than what's set out in their contract. Consider perhaps putting them on gardening leave, so saying, well, we'll get you to work out your notice, but you don't need to do any duties. That will give them some time where they don't have to work and they can sort out their visa situation while still getting paid. Or consider allowing them to use any accrued unused annual leave, which you'll need to pay out at the end of termination anyway. So doing all those types of things won't guarantee that you won't get an unfair dismissal claim. It just means that if you need to respond to one, you'll win some brownie points, in my view and my experience, from giving the applicant, the visa holder, some more time to sort out their affairs. And a final thing is, we see quite a lot of discrimination or general protections type claims from visa holders who often allege that it was because of their race or their nationality, etc. That was the reason for their termination or for certain discriminatory conduct. So again, if you think you're in that space where you're dealing with a visa holder and termination and you think things could get a bit complex, they're things that we can assist with. I think that might be... oh, sorry, just mindful of time. I'll just, so very quickly, so what to do when the Fair Work Ombudsman or the Department of Home Affairs come knocking. So under the Fair Work Act, the Fair Work Ombudsman actually has very, very broad powers to actually turn up unannounced at a business. All they need to do, all the inspector needs to do, is to show their ID card before coming into the premises, and they can't forcefully enter the premises. But Fair Work inspectors from the Fair Work Ombudsman will often have these surprise visits where they've been tipped off by an anonymous complainant that there's some sort of potentially unlawful conduct happening within a business. So that could be not paying staff correctly or allowing people to work in breach of their visa conditions. So if you do receive a surprise visit from the Fair Work Ombudsman or a notice from the Fair Work Ombudsman that they want you to provide certain records in relation to your workforce, then again, that's also something that we can assist with. And I'll hand over to Yvette, who can talk about, sorry, next slide, please, what to do if the Department of Home Affairs comes knocking. You're just on mute, Yvette.
Apologies. Much like the Fair Work Ombudsman, the Fair Work inspectors are deemed with powers to actually conduct inspections in relation and pursuant to the Migration Act. Often they'll attend where they believe there might be a breach, for example, relating to a sponsorship obligation. And so you have an obligation, as we mentioned earlier, to cooperate with inspectors, and that would include if they came to your premises to allow them in. They have powers to enter. They would do it without force. So obviously cooperating with them would certainly see you in good stead. Some of the things they may want to have a look at are records, for example, or documents that they believe might be relevant relating to a breach of a sponsorship obligation, and it could include accessing computers on the premises. So just be mindful, if that ever occurred, they have that power. But they do need to show your ID, of course, to confirm that they are inspectors. And obviously the powers of inspectors are set out very clearly under the Migration Act. I'm not going to go through those now, but you can certainly view them, or if anyone is interested, I'm happy to send those sections across. It's now 2:00 and we want to open it to questions very quickly if you have any. I have seen one in the chat box, and the question relates to, it's an immigration question. It says here, if a casual employee holding a student visa completes their study, is a new visa required to engage in full-time employment? So it's a two-pronged answer to that. The first would be, so if they've completed their studies and they're working with you, obviously their course is no longer in session. If they've completed their course of study, they can work, but it's one of those grey areas whereby upon completion of your studies, your student visa does have an expiry date. And more often than not, they do prefer that student visas, if they're not going to stay in Australia, that those visa holders do depart because their course now has completed. If they are planning to stay on, then they should regularise their status and actually either approach you as their employer to sponsor them if they're eligible, or look at getting another visa that's more appropriate. Often some of them will move on to what we call a graduate visa, the 485, before they then move to either sponsorship under a 482 or other programs that they might consider like an occupational trainee. So to answer your question, yes, they could continue to work, but be mindful there might be a compliance issue if they're there for an extended period, and be mindful also of when the student visa expires. If ultimately you're going to offer them a more permanent role, you're better off sponsoring them or getting them onto another visa that's appropriate so that they can continue to work for you full-time whilst not on a student visa, preferably. There's another question here. I'm happy to take, or have they deleted it? No, it's there. If an employee has completed a student visa and he's on a bridging visa to work towards a 482 visa, what work conditions would this employee still hold? Generally, bridging visas carry the same terms of conditions as the original visa held. So the original visa that was held was the student visa. And so those conditions would apply. However, the course is no longer in session, so they can continue to work for you until such time, full-time, until their 482 visa is granted, provided it's granted. So that's the answer to that. So the conditions would be the same conditions that bridging visa would hold as the student visa, that work limitation would be on there, but out of session, they would be able to continue to work for you full-time until the 482 is in place. There's another question here. Do you provide the service of a migration lawyer instead of us having to outsource lodging this? So do you mean like an in-house? We can outsource and come to your premises and do particular work if that's something you wanted us to do, but that would be as a contractor. So we would be subcontracted to you to provide immigration services. I'm not sure, Cassie, if that's actually the question you're asking. But we could have a chat further about what the scope is specifically that you're after in that sort of question. So more often than not, you would enter into a contract with a migration lawyer or an agent, and they would undertake and look after all your visa applications for you. That's often the way we work with a lot of our clients. We have an agreement or a costs agreement with our clients, and we lodge those applications on their behalf, but it's under each of the migration agents or lawyers have a profile with Home Affairs that authorises us to act and actually lodge applications on behalf of our clients. So we can, that's how we're allowed to do it and authorised to do it. So we each have a number. Lawyers have a legal practice number, and migration agents have what we call an OMARA number. Migration Agent Registration Number. Any other questions? No other questions? I think we might be good to close, but Lisa and I would like to thank you all for attending today. And it brings us to the end. Keep an eye in your inbox for an email with today's webinar recording. So if there's anything you'd like to discuss in relation to migration or legal, employment law in particular, you can reach out directly to Lisa or myself. Our contact details are on your screen there, but you can also scan the QR code to access key resources and learn more about our services. So thank you so much, and we hope you enjoy the rest of your day.